We finally made it, the big one. Companies, the corporate form. We're going to look at what a company is, some of the key ideas behind a company and why it is such a popular form for running a business. And we're going to deal with some of the key players and terms you should be familiar with. Okay, let's get into it. The company form. To fully understand a company and its impact on society, I think it is useful to have a look back in history at how we've traditionally run businesses. So why don't we do that? Let's have a bit of a look at the history of the company form and its impact on society. One of the big things I'd like you to take away from this particular video is the idea about how recent companies are. It's only really in the mid-1800s, not even 200 years ago, that the company becomes a way of doing business. If you look back in history, there were some kinds of companies around, but they were really operated when the elite gave a monopoly to someone. So universities were one of the first forms of corporation. They were recognised as a community that needed its own corporate form. And other ones were things like guilds, religious orders, and that kind of idea does go back to Roman antiquity and ancient, where there were very few companies that were given the imprimatur of the state to operate. But they weren't really companies like we think of them now. With the great trading companies out of Europe in the 1600s, we start to see the idea of a joint stock company, but these were given by royal charter. So that means you had to actually get the king or queen to say you were allowed to set up a company. That was the only people who were allowed to. They were very limited. They were given monopolies, which gave them enormous power and influence and an ability to make money. And so they're not really companies as we would think about it. They're almost their own small nation states. But as time unfolds, we start to see the Industrial Revolution take off. We have the Enlightenment and we have the Renaissance, which brings on these ideas of liberalism and laissez-faire, and economics, which starts to take a view that competition is good, that we need trade, right? And we couple that with the Industrial Revolution. Why the Industrial Revolution? Because the kinds of things you wanted to build, railways and factories, required an enormous amount of money, more money than one individual or one family had. So when you couple this idea that we want several competitors and we need lots of money, we need a new idea. And that idea comes in the form of the Joint Stock Companies Act, which allows people to pool money and form their own separate legal entity. Bingo. This is the innovation. But they couple it with a second innovation where they limit the liability of the business to this legal entity. These are the two key innovations. And why is this limited liability such an innovation? It allows the company to take more risk than an individual would normally take, right? So if you're a sole trader and you lose money in a business, then whoever you owe the money to can come and sue you and can take your house. But if we limit the liability of the business to the legal entity, your house is safe, something we'll come back to. This is what spurs the modern economy, and the corporation has been likened to have more impact on our quality of life than the invention of the steam engine and electricity combined. That's a huge impact, okay? And I think it goes under-recognised. In Australia, we adopt similar legislation in each state. So originally corporations were state-based, where although the Constitution specified that certain industries like telecommunications were to be regulated by the federal government. So there's this mix, right? And it becomes very difficult to do business in Australia because the state have the power over some companies and the federal government has power over other companies. There was this gradual move from separation to a harmonisation of these laws in the corporations laws, as it was called then, till the states gave up the power to regulate corporations altogether. So the states gave away that power to the Commonwealth, and in 2001 we get the Corporations Act. And that's the way corporations are regulated within the Australian environment. Now, I hope that wasn't too boring, but I really want you to get this idea of this innovation and the huge impact it's had on society. We can just take it for granted. We just think that there are companies there. But without these forms, without the separate legal entity, without the limited liability, we wouldn't enjoy the life and the society that we do today. Albeit, there are some things about controlling accountability in corporations, which we're going to get to in the next 2 weeks. But don't throw the baby out with the bathwater. There's been huge benefits that have come with it. Okay, let's get into some more details about the corporate form. So a corporation in Australia has these 2 defining features. It's a separate legal person. It has limited liability. What does that mean? It goes on forever, right? Unlike a person who dies, if you're a sole trader and you die, that's the end of your business. Not a company, right? Let's look at the alternative to really try and spell out what's going on here. So you might remember that I've got my business Gavin's Rings, and if I'm running that as a sole trader, right? Now just say I've done so well, I need a shop. So I need a lease for the shop, and then I have 3 employees to help me with the shop, and I have metals suppliers, and suppliers of my tools, etc., and I might have a bank loan. And we know from the sole trader video that I have a contract, and here they're contracts of employment, that I have a contract with each of these bodies, or there could be several different organisations here who I contract with, etc. But you get the idea. It's me, it's Gavin having these contracts. What happens in a company? Well, instead of Gavin, we have Gavin's Ring Proprietary Limited and Gavin's Ring Proprietary Limited contract with the landlord for the shop, with the employees, with the bank, with the metals suppliers, with the tools suppliers, right? So that if I were to die in an industrial accident, what happens here? Well, there are no more contracts, right? I'm dead. What does the shop owner do? These contracts are no more. I'm dead. If I die here, it's all still operating, right? Because the contract is not with me, it's with this company. Okay, that's pretty morbid if you die. But what's one of the advantages of this approach? The advantage is if I've actually want to sell the business here, I have to change all the contracts. Here, I just sell the shares in the company. It's so much simpler. I don't have to get the lessee to agree to a change of lease. The lease stays exactly the same. I just sell the shares to a new controller. That's what perpetual existence gives you. Not only the whole death issue and the idea behind succession being easier, it gives you an easier way to exit. You can see in my second example, it's Gavin's Rings Proprietary Limited that has the loan, that has the lease, or it could even own the shop. If there's an industrial accident or negligence, you sue Gavin's Rings Proprietary Limited, not Gavin. You can sell it, and yet I still have this legal relationship of the share ownership in what I actually have. So if Gavin's Rings Proprietary Limited is the actual owner of everything, how does it do anything? It has agents who do the work for it. Who are the agents? They're the managers and the directors. That's why we needed to understand agency law, right? That's how this legal fiction of the company owns everything, but it's operated by the agents. And really importantly, the liability, like if you can't pay the leaser can only sue the store. It can't sue the shareholders. Shareholders' liability is limited. Huge innovation, and one of the main reasons that we have companies. Whew. Hopefully that gives you an insight into why we have companies and what's going on from a legal perspective with the corporate form. So a company is a specific type of corporation. We will do a very short video on some other kinds of corporation, and it's incorporated under the Corporations Act. There are some key positions that you need to know about. The members. Under the Corporations Act, it talks about members, not shareholders, because there are some non-profits where they're not shareholders, right? So shareholders and members mean the same thing. There are directors. So the members or the shareholders elect the directors. The directors as a group make all the decisions. What they normally do is appoint key managers. Those managers we call officers. That's why there's so many O's in titles. CEO, Chief Executive Officer, CFO, Chief Financial Officer, COO, Chief Operating Officer, Chief Technology Officer, CTO, right? You get it. O means officer. They have a key role and there are some duties and obligations that arise specifically to them under corporations. They're the main day-to-day agents of the corporate form. The directors are also agents. They take a more high-level position and then delegate the powers to the officers. There's also another important position, the company secretary. They keep the records of the company because there's a lot of regulation of companies. So they have to keep the government updated about who's a director, who's an officer, what do we own, what's going on, how's the tax situation. They're the ones who are held responsible for making sure all that stuff gets done. Now, while there are these positions, you can hold more than one. So you can be a shareholder or a member. You can be a member and a director and even an officer. You can be in all of those positions. So if I started Gavin's Rings Proprietary Limited, then I would hold all three. I would probably be the shareholder, maybe 100% shareholder. I would be the director of the company, and I would also be the chief executive of the company. But they're different roles. You have to think of them like hats. A person can wear many hats, but they're different hats and they have different rights and obligations. So as I said, if I ran Gavin's Rings and I held all three hats and there was a negligence problem, just say there was an industrial accident, someone gets hurt making rings, then I can't get sued as a shareholder under my membership hat, but I might get sued as a director or as an officer under that hat because I have different obligations. So don't think that this limited liability means there's no accountability. There is. They are directors' and officers' duties, something that you may learn about as you go further in your degree. What we limit, though, is the shareholder. So if you gave me some money as equity and became a shareholder, if there's an industrial accident in my shop, you can't get sued. And that kind of makes sense because you have no control over that, right? So you shouldn't be getting sued. That's what the limitation of liability is. So it is possible for one person to still run a solely owned business through this form, and technically you do limit your liability, but I think a better way of thinking about it is you change your liability because rather than you being just responsible as an individual, now you take on directors and officers' duties, etc. But it can help in doing things like protecting your assets, etc. So that's what's going on in terms of the corporate form. They are some of the key positions: members, directors, officers, company secretary. Now, so we've talked about companies as a whole, but there are actually different types of companies. Let's have a look at that. So the Corporations Act does allow for different types of companies. There are some that we don't use much, unlimited liability companies and no liability companies. They're rarely used, so we're not going to really deal with them. They're for specific instances. There are also companies limited by guarantee, which I won't spend a lot of time in. They're generally for not-for-profits. So rather than limiting liability to the share capital, that's the traditional way that we think about it, it limits liability to a guarantee. What do we actually mean by this? This means, look, for instance, if you have shares that are worth $1 and you buy 100 of them and you put in $100, right, to buy and you get 100 shares, your liability is limited to the share capital, to the $100 you put in. What that in essence means is that the company can lose your money. When the company gets sued, they can take all of the equity that you put in to pay other people back. That's what your liability is limited to. In terms of these not-for-profits, it's limited to a guarantee. So you might not put $100 in. Instead, you guarantee or promise to pay $20 if the company can't pay its debts, right? So it's limited. Your liability is limited to this $20 guarantee. In the case of shares, it's limited to the share capital. Just a quick aside, this is not a finance class, but you need to understand conceptually the share capital is the face value of the share, not the market price of the share. Two different things, right? When they issue a share, there will be a price, right? The face value of the share. That's what it's limited to. So sometimes the face value of a share when it's first issued might be $1 a share, but it might be trading on the market. For you to buy it now, you have to pay $20, right? So you pay the full $20 in. But really, it was always limited to that dollar because that's the face value, which was paid by the first person. You're now trading something. You're now trading this share on a market, not limiting your liability in this contract, etc. That's all taken care of by the first person who buys the share. In a second way, it doesn't mean that all shareholders never have to pay money if a company goes broke, because sometimes shares are only partly paid up. I won't go into the details, it's a complex issue, but sometimes the face value of a share might be $1 and you only pay 50 cents. If the company goes broke, you're going to have to pay another 50 cents for every share that you own if the company goes broke, right? So that means you need to be quite careful when you're dealing with partly paid up shares, because you might actually be taking on a liability you don't know about. Anyway, that's the basis of what limited liability actually means. If we turn now to the main forms of for-profit company, companies limited by shares, we see that there's two different kinds: proprietary limited companies, PTY LTDs, and public companies, limited companies. And you'll see that in the name. That's how you can tell the difference. Within public companies, they're the big ones. There are listed public companies. These are the ones on the Australian Securities Exchange, on the stock exchange, right? There are a couple of other exchanges like the Bendigo Exchange in Australia, but these are listed publicly. The public can invest in them. The public can also invest in LTDs that aren't listed, so they might not be on the exchange. And in fact, and while the numbers vary, there's approximately somewhere around 2,100 to 2,200 is a pretty good guess, maybe even 2,500. Somewhere around that is the number of listed companies in Australia. But in terms of public companies that aren't listed, bit of a guess, but it's running about 7,000 companies, whereas proprietary limited companies, 1.2 million. This is where most of the companies are, not listed on the stock exchange, etc. And these have very special rules around them, like continuous disclosure. So as you go across this spectrum this way, the level of regulation increases greatly, because these companies over here have much more impact on Australia. They're bigger, the public can invest with them, etc. So there's a lot more stakeholders involved with them. So they have this huge impact, so we expect more of them. We regulate them more. Down over here, the small fish and chip shop run by mum and dad on the corner is more lightly regulated. 1.2 million in here, 7,000 around that number for public companies that aren't listed, and about 2.5 listed companies. You'll also see here that there's a distinction between small and large. Okay, so the Corporations Act uses a 3-part test. It's about asset size, turnover, and number of employees. And if you're above a certain size in 2 out of these 3, it considers you a large company. Why? Large companies have a bigger impact on society than small ones, so we regulate them more and we expect more of them. Okay, we're not going to go into the huge details in what the increased regulatory requirements are. That requires far more detailed study. Just recognise that while we talk about companies as a group, we need to understand the difference between PTY LTDs and LTDs, and we need to understand that they run from small PTY LTDs up to listed companies, and they have different expectations on them in terms of their regulation. And so I'll leave you to look over the types of companies, the details below, but what you can see is the private or proprietary limited company, PTY Ltd, are mainly set up for those people as they start a business and running most of the businesses that you interact with. Family firms, small businesses, small groups of people, I almost call them partnerships, but we know that's a different legal form, where groups of people get together to run a business, 3 or 4 friends, etc., run it in a corporate form. That's going to be a PTY Ltd. Once you get a public company, you have an ability to go and raise equity from the public, from the general public, and different rules and requirements come in. And you will know that they have the LTD in their name. As part of what they must do, they must have more directors because they are dealing with public money and they've got to have this public forum, an AGM. Okay. Different kinds, PTY LTDs, LTDs. PTY LTDs, how you start a business, smaller businesses, not like scaling globally, etc. generally, versus a public company. If you need to raise lots of capital, lots of equity, you're going to go big. That's a public company and eventually list. And that brings us to our summaries, the advantages and disadvantages of a company. Hopefully they're pretty clear. Separate legal entity, limited liability under a company. You have perpetual succession. You can raise equity, and you can even go to the public and raise equity under some instances. You can get experts in as the agents who run it for you, the managers, the officers, and the directors. And it's very easy to exit whenever you want because you can simply sell the shares in the company. You don't have to deal with that tangled web of that you have to deal with in the other legal forms. But there are some disadvantages. It can be a costly way to begin a business. Not only that, it's costly as you keep going because you're going to have accountants' fees, you're going to have to lodge forms, you're going to have to do all of that paperwork that's involved with having a separate legal entity. You start to limit your rights as an owner because it's no longer your business, you're just a shareholder in the business. It's a big distinction. At the smaller level, it probably doesn't make that much of a difference, but as soon as you have another shareholder, there can start to be challenges with that. You've lost that total control that you have, particularly from the sole trader. You start to have to tell the government more about what you're doing through the release of information. And despite what you may think about limiting your liability in a separate legal entity, if it's going to be your business, you're going to start taking on new responsibilities, new accountabilities through directors and officers' liability. And finally, something that we're not going to spend a lot of time is, but because it's a separate legal entity, if the company makes money, then it has to pay tax on that profit. Then what's left over, if you take that as a dividend, you're going to have to pay tax as an individual share. So you're going to be double taxed from what comes out of it. It's not as simple as that. There are some ways that you can work with that, and I'll leave it at that. But in essence, you can end up paying a lot more tax through the company form. And so in the end, you have to weigh this up. Are the advantages for where I want to take this company worth the disadvantages for the corporate form? And that was the last one that we look at in terms of the kinds of structures you get to choose when you decide on the structure for your business. Very briefly, I should add that there are other corporate forms you should be aware of that the government actually controls or owns, if you want to think of it that way. It's probably not the best way to think about it, but it's a way to think about it. The two big ones are government-owned corporations and statutory authorities. They're not run under the Corporations Act. There are separate laws that allow the government to set up these corporations. And they have similar but different requirements. They are still separate legal people. They still have limited liability, but some of the other stuff changes around them. And there are some other forms out there that you should be aware of. But I think for this particular subject, concentrate mainly on that idea of a company. And that's all we have for this particular module. Hopefully there's been something useful for you in it.